January 18th meeting of the zoning board of appeals in the 1820 courtroom, town hall, 26 Court Street, Plymouth, Massachusetts. Tonight we have one case and some administrative things to do afterwards. But before we get started, I want to talk about something a little bit to the proponents and everybody else. We're 7 volunteers here. All of us, or most of us, work full-time or part-time or whatever. We don't get paid for any of this. And now I'm going to talk to the attorneys and the people that wanted to present a whole bunch of stuff. As of yesterday at 3 o'clock in the afternoon, I got a 34-page document. I haven't had time to read 34 pages between then and now. Our attorneys got inundated with stuff. Mr. Serby, you're part of it, which we don't appreciate. We need time to study stuff, and we don't appreciate having something last minute dropped on us. Excuse me. We don't like it from any of you. It just takes too much work. Consequently, half of the stuff that we got yesterday, people have not had an opportunity to read. So we can't rely on that information as testimony, because we don't know whether it's right or wrong or what it is. We haven't had a chance to look at it, and that just doesn't happen. Not in this world. What we do, and I want everybody to understand this, what we do is we are an adjudicated board, and that means that anything we do has to stand the strength of the courts. And everything that we do is registered on every one of his deeds if you come before this board. And when things are put on this particular document that we're trying to get done tonight, those things have to be done. And in order to do that, we rely on the facts from engineers, the facts from attorneys, the facts from butters, all of the facts from our own town people, and we need time to study that. And we have not had that time. So we're going to go ahead tonight, but I don't know how far along we're going to get. And what we're going to do now is the New Hope Chapel case, and I will have the clerk read the advertisement.
Case number 4041, the Plymouth Zoning Board of Appeals on the zoning bylaw will hold a public hearing in 1820 courtroom, Town Hall, 26 4th Street, Plymouth, Mass. on Wednesday, January 18, 2023 at 7 p.m. to hear the petition of New Hope Chapel, Plymouth, requesting special permit for section 203, 2C5 for earth removal of 68,606 square feet, cubic yards, CY, for a proposed church for section 203, 2C6, Roman 6, Roman 2I, to allow side slopes exceeding 3:1 grade for section 206, 1-L, use table 13 and 43, and within aquifer protection district, area 3, for parking of more than 200 vehicles and storage of snow on the property of New Hope Chapel, Plymouth, located at Joshua's Way, shown in lots 36-1, 36-2, 36-3, 36-4, and 36-5 on plat 66 of the assessment map dated January 1st, 2022, in the RR zone. The petitioner or his or her representative and any other person desiring to be heard on this matter to appear at the time and place designated.
Seated on this case will be Mr. O'Reilly, Mr. Leary, Mr. Conroy, and Mr. Rafferty, and myself. Who will be Mr. Simmons.
Good evening, Mr. Chairman, members of the board. My name is William Sims. I represent
The
the
light
How
one?
am I doing now?
Good.
Better. All right.
Better. Yeah, you got, folks, this room, we spent a lot of money to build this building, and it's really in pretty good shape, except for the acoustics in the 1820 courthouse is still the acoustics of 1820. So if you come to the microphone, please speak up.
Testing 1, 2, 3. Good? Okay. I don't want to be too loud. I want you to hear me. Good evening once again. Mr. Chairman, members of the board, my name is William Sims. I represent the petitioner in the Little Chapel. With me tonight is Mr. Glenn Tremontori from the Trade Development Services from Virginia Beach architectural firm. Mr. Rich Jabozinski from Atlantic Design, our project engineer. So I think as the chairman mentioned briefly, I echo some of the sentiments. My plan tonight was to jump right in with our team's presentation, but I feel compelled to address some preliminary issues. First, I know there are no formal and published ZBA rules in terms of submissions, in terms of memoranda, documentation, and so forth. I know the planning board has recently enacted some of those procedures, but I don't think there's anything that the ZBA has done so far that requires timelines in terms of that. And as late as yesterday afternoon, I was provided with the same email communication that you got, from the opponents, which gave me little or no opportunity to provide any adequate response. I'll do my best to address some of that stuff tonight, but clearly not enough time. It's putting us at some degree of disadvantage. In any event, we're prepared to go forward as we have. I've provided our submissions, and we're going to move forward with that. Secondly, it's my hope that tonight's hearing will focus on the special permit request filed by the petitioner and will not be derailed with comment and discussion about what may or may not have occurred in the subject property over the past several years. 2 weeks ago, I was here when this board unanimously denied the zoning appeal filed by, say, the Pine Barrens Incorporated, looking to override the building commissioner's decision. So with that decision, I believe that they've effectively removed from the scope of this hearing any discussion relating to alleged earth removal. So we should no longer be going down that road and entertaining any further discussions on that particular topic based on this board's decision. In addition, I think in the public forum, as well as for this board, planning board, and other members from town government, there's been a lot of misinformation proposed and presentations which I think grossly and inaccurately represent and describe the scope of this project. The details about gravel removal, parking, aquifer protection, and other matters like sound, finances, and activities that preceded the New Hope Chapel's acquisition of the property and are far outside the concern of this board. For those issues, and within the purview of this hearing and our petition, we will address most, if not all of these issues, with hopefully some accurate information for this board to assess and make an informed decision. We will present our studies, which have been conducted over years at this point, and involved engineers and architects and traffic engineers and enough information so that we feel very, very comfortable presenting to this board some very detailed information which will adequately protect the abutters, the town of Plymouth, the resources of this town, the community involving, setbacks, open space, parking, and coverage. So at a minimum, I just think that we should not lose focus. The petition for the board seeks special permit relief from sections 203-2C5 of the zoning bylaw for earth removal, parking for more than 20 vehicles pursuant to section 206.1 in the Aquifer Protection District, and also 203-2C6 to allow the side slopes exceeding 3 to 1 grades. I'll try to cut this down as best I can because I know we have a lot of speakers tonight. But just by way of background and history, The New Hope Chapel of Plymouth was founded in 2002 by a small group of families. In 2009, the membership had grown to 250 people, and they entered into a lease agreement with the town of Plymouth for the Cura building, which New Hope undertook substantial renovations at that time. The church and its congregation continued to grow, exceeding over 450 congregants, not of all up here at one given time, but the membership stands at about that number, last count that I have. So the decision was made that the church had to expand, relocate to a larger, more permanent facility within the town of Plymouth to accommodate the constituents and, most importantly, the Sunday services, in which there are two. It's anticipated that the relocation in Joshua's Way will comfortably accommodate all the needs for New Hope without placing any burden on town services or disruption to the neighborhood. The Sunday services average about 150 attendees in the early morning service, and then about 300 in the second service, which takes place about, I believe, around 10:30 in the morning. The facility will also conduct children's programs on Sunday, and other than maintenance staff, administration, the facility will mostly be vacant for most of the week. There would be an average of about, I think, somewhere between 10 and 15 people once or twice a week for things such as worship rehearsals and such not. As you'll hear later on from the architects, that there are no doorways or windows in the sanctuary, which is in the center of the building and surrounded, we can see it there, it's surrounded by classrooms and offices which will absorb the sound and lighting, so anything emanating from the building will be absolutely minimal. In August of 2020, New Hope Chapel purchased the 18-plus acres, as you've seen here on Joshua's Way, in an effort to develop the site to construct the structure of the new church. It's important to note that this site was originally designed as a 5-lot subdivision, fully approved by the town, and permitted and partially cleared prior to the New Hope Chapel location. This property, as you know, is in the RI district. The original application, which was submitted in October of 2021, called for construction of a 53,689 square foot building with 365 parking spaces and seating for 1,350 congregants and the associated removal of 302,000 cubic yards of gravel over approximately 2 years. Best I could recall the original application, which I was not involved with. However, doing their best efforts to meet with the abutters and other concerned citizens, the church went back to their engineers and architects, understanding the concerns of the volume and size of the church, and they redesigned the entire project. A new petition, the original petition was actually withdrawn, and a new petition was filed with radically changing everything. The new plan development now includes the construction of the church down to 26,618 square feet, I believe, with only 787 seats. We're still including the classrooms, bathrooms, nursery, worship area, offices, and storage. Plan use facility includes Sunday-only worship for the congregation. During the week, again, there will be very limited use of the facility. There will be occasional Bible study, which includes maybe 10 or 12 members. Maintenance staff, and a few others will be on site. The administrative offices are planned to remain at 89 Court Street. There will be occasional planned events, which will be held indoors. On very limited occasions, attendance will be substantially less than the Sunday church services. For example, the church holds a vacation Bible school, attended by less than 100 little kids for 4 nights. Seating in the church, as I mentioned, has been reduced to 787 from the original plan of 1,350. Parking spaces reduced to 360. And in compliance with the number of seats, now to 780, that is being touted by some of the opponents again. Some more information. Gravel removal has been scaled back from the original number I quoted to 68,606 plus or minus 100 cubic yards, to be removed over a period of approximately 6 months, but I'm told by my engineers that it will be substantially less than 6 months with that number. When reviewing the RR zoning requirements here, you can see that not only does the project meet the requirements, it far exceeds them. All of our numbers exceed the numbers in those tables, including dimensional and intensity requirements, subject to only special permitting for any requested additional relief. So most importantly, or as part of the presentation tonight, I think it's important and progress is very good to recognize that this case falls under both the federal and state regulations, the federal being the what's known as RLUIPA, the Religious Land Use and Utilized Purposes Act of 2000, and of course Massachusetts General Laws Chapter 40A, Section 3, known as the Dover Amendment, which was acted somewhere around 1950, I believe. These statutes, as I believe everybody is well aware, provide that religious, farming, child care, and educational uses are exempt from local zoning regulations. Statute provides, among other things, that no zoning ordinance or law, bylaw, regulate or restrict the use of land or structures for religious purposes, provided, however, that such land or structures may be subject to reasonable regulations concerning the bulk, height of structures, determining yard size or lot area setbacks, open space, parking, and building permit requirements. Further, the federal law requires that permit granting authorities use, and I quote, the least restrictive means possible to address issues with proposed construction. So the special permit granting authority, which is the zoning board, cannot over-regulate in this regard. This would apply to any proposed conditions to the grant of special permit. So if the special permit is granted and conditions are imposed, they can't over-regulate those particular conditions. It has to be something reasonable under both federal and state law. So notwithstanding the foregoing, it is our position that the plan presented by the petitioner is thoughtfully and strategically designed to provide minimal impact on town resources, neighbors, and unlike the already approved 5-lot subdivision, it could significantly impact town services and resources by adding 5 large independent septic systems and increasing the water supply, and obviously substantially less open space set aside. So in general, I think the siting of this particular facility is far more attractive than what would have been a 5-lot subdivision when it comes to taxing town resources and abutting neighbors. So in preparation for tonight's meeting, we researched cases relating to Chapter 48 which would be of some benefit. Unfortunately, there is very little out there which focuses directly on the issues at hand tonight. But the courts have typically aligned the intent and application of statute, determining that the unreasonable regulations of religious structures. So the language in some of these decisions, and strangely enough, 2 cases involved Plymouth, use terms such as judges should not interpret whether a conclusion of a particular architectural feature is, quote, necessary for a particular religion. And the town should not require a religious organization to apply for special permit to obtain a building permit to construct things like a ball field, snack bar, and lighting, but to change the use of existing buildings to classrooms. So essentially what they said was that, in Massachusetts, it comes down to a determination of what is being proposed is the primary function of the construction of this particular project. And that gravel removal is ancillary there to not part of the actual process, which is precisely what is before you tonight. In my reading of both federal and state law, it makes it clear that the special permit granting authority has limited discretion in that regard. It must make a clear determination that the gravel removal is the primary purpose of the project, and then it could decide, in that event, if you made the decision that this project is being built just to remove gravel, mining as some want to call it, then you can decide that it's inappropriate and should be regulated. But short of that, I think that reaching that conclusion would be an extreme hurdle to overcome these circumstances. For example, I think that the construction of this church will cost somewhere, I don't know, maybe 10 times whatever the value of that gravel is. So even if the gravel is worth, whatever number you want to associate with it, the construction of this church is going to cost somewhere 10 times that. So we can't associate the construction of the church as an independent mining operation for the sole purpose of making money. It just doesn't work in this particular scenario. It's not even close. And unlike the case, which was argued by my opponents in their number, where there was the old colony case where the Boy Scouts attempted to build a cranberry bog, and as part of that had a snack bar operation, but the ratio between the money and volume they would receive from the excavation of the bog far exceeded that of what they would ever receive in return from the snack bar concession stand. That's not this case at all. The opponents have also argued the theory of estoppel, in that the special permit components are stopped because they did not appeal the building commissioner's decision. I'm a little bit of a loss on this one. It doesn't make sense to me. We, just like every other petitioner before you, has to come before this board with standing. We have to file an application with the building inspector, and if we can't come before this board until the right's denied, need a special permit. That's why we're here. So I don't think the theory of estoppel applies in this case at all. And you can't get standing until he denies the application, and like I said, it says you need a special permit. You can't get here any other way. So I think that this project can best be identified as accessory to the principal use. Principal use, as set forth in 26 from the bylaw in the RR district. This is not what has been classified by some as an independent mining operation. We can't build this structure without the removal of a relatively small portion. I call it relative because we have 18 plus acres of land there. We're talking about 68,000 approximate cubic yards to be removed in order to make this site accessible, make it work, design, and redesign. As some of you have seen the site, you understand the contours make this a very challenging project in and of itself. As the ZBA, Special Permit Granting Authority, has a decision to grant the request of relief under 2026, the ZBA has the ability to waive or modify dimensional and other requirements, which of course we have requested in our application. I would also suggest that everything about this project and the requested relief is reasonable, even without the afforded protections of the LUPA and the Dover Amendment. The siting of this church is on, like I said, 18 plus acres, and that's of paramount importance. The design, the redesign, the engineering, all have been prepared with cognizance for building which is least intrusive to the neighborhood and will have minimal visibility from all angles. The removal of the 68,000 cubic yards will permit the structure to be located at the level where this low visibility and substantial buffer can be accomplished. We believe that the period of time posed for this removal, and I suggest respectfully that even though we went for the planning board and suggested 6 months, I think it will be substantially less than that based upon the calculations by our engineers. And I think that's exceedingly reasonable under the circumstances. And you will hear from the engineers as to the timing of truckloads, the precautions and measures taken to deal with traffic controls, staying away from school buses along Plymouth Road, and everything that would affect the community during this period. I think the siting of the site, the location of the site, and grading is of critical importance. I don't think we want to see this project deny the ability to remove the gravel and having to build this at a higher level. It becomes a safety concern, it becomes a visibility concern for everybody around, and I think that it's most important that we acknowledge that as well as all the other issues that I've referenced so far. A couple other things to mention. The The ZBA has the ability to waive or modify dimensional other requirements, as you all know, but to further reduce the earthwork cuts, the parking areas and recreational fields have been located in an area to avoid higher elevations and hills on the site. And as we get into the architectural presentation and the engineering presentation, you'll see that the parking areas have been graded, sloped up and away from the building, which reduces the excavation cuts on the site. Graded the recreation field is terraced at a much higher elevation than the building parking areas, thereby reducing further excavation cuts on the site. As it relates to the Aquifer Protection District, a special permit, as you know, is required under Section 2061, number 13, parking more than 200 vehicles. Parking plan is essential to this particular project for a number of reasons, not the least of which is safety. If we don't have ample parking and congregants attend services, we're going to end up having people parking on Joshua's Way and maybe trying to squeeze cars in on Long Pond Road. So I think it's particularly important that we recognize the parking situation is relevant, important, and makes really good sense to this particular project. We want everybody off the road, off Joshua's Way, and in a parking lot. This property is also located in Area 3 of the Aquifer Protection District, which is by, I'm sure you all are aware, the least restricted of all the aquifer protection zones. It only applies to surface waters, recreational areas. It is not something which is a constraining factor to the municipal water supply. By way of comparison, I believe there are allowed uses in this particular area of things like auto repairs and storage of gasoline and other things which are far more dangerous and intrusive than just parking cars and our church being located there. I think, if I recall the plans correctly, I think we're something like 2,000 feet from the closest Aquifer Protection District area. So, arguably, we shouldn't even need relief from that particular bylaw. There are a number of other things which have been presented by opponents at the planning board stage. The Wildlands Trust appeared and suggested that we fence the entire perimeter to protect them from various things such as ATV vehicles and stuff. I mean, that becomes, again, overly regulated to fence an entire property, which is, if you've seen the site and the project, and if you haven't, you will see it's wooded entirely in the back of the project, which abuts the Wildlands Trust area, which goes then back to the TCIS property. There's no evidence to suggest that there'd be any issues with people trespassing on our property and accessing the Wildlands Trust property. It happens, I mean, it's a trespass. It's not an issue we can regulate reasonably. So in general, I guess if this project was not subject to the Dover Amendment or the federal guidelines under LUPA, I think it would still need to exceed all the requirements for any other building associated with the premises covered by Section 207(1)(c). You will see that the traffic study presented will indicate stopping site distances in both directions being well addressed, 75 to 80% of the site reforested with native species, building meets the height requirements, the design exceeds the requirements for lot size, lot coverage, and open space, and obviously lighting will have to be compliant with 2074. That is the extent of my presentation. I apologize for exceeding what I thought was going to be brief, but in any event, I would like to reserve my right to address the board again after hearing opposition if I feel it's appropriate. And at this point, I'll turn this over to our architectural firm and Glenn Trematore to discuss and show the architectural designs and answer any questions the board may have. Thank you.
Thank you, Mr. Simmons.
Yeah, I'm a little shorter than he is, so testing. This is working.
Would you, because it's being recorded, would you identify yourself?
Sure. Glenn Trematore. I'm the CEO of Church Development Services, and we provide architectural